Hello everybody, I'm Lucy Reed. I'm the chair of the Transparency Project and I'm a legal blogger. I'm going to be taking the lead in today's session. Thank you very much for joining us. If either after today or if you hear from other colleagues who want to learn a bit more about this training, we will be sending around a copy of the recording, and please feel free to share that along with the pack for today. First thing to say is in terms of ground rules really, or the structure of today's training session, there is quite a lot potentially for us to cover today. We probably can't cover everything. I'm going to move my face out of the way. We probably can't cover everything in as much detail as we would like to today. So we're going to jog through things at a relatively fast pace. But we will have some time for questions if there are things that perhaps you've not quite grappled with as we go through. And we've intentionally given you quite a full pack of information, including some material that's not going to be in today's presentation, so you can kind of process and get a bit more detailed information after today. And as Julie has said, we will record the session, but we've deliberately taken a decision not to record the Q&A because we wanted you to feel at the end that if you've got a question, you can ask your question, you can put it in the Q&A box and it can be read out without identifying you if you prefer. And there is no question that is too daft to ask. There's a really mixed base level of knowledge. Some people will know quite a lot about this topic and some people won't know anything at all. So please just ask questions at the end if you would like to. If Julie spots anything in the chat that she thinks could usefully be tackled as we go through, then she's going to prompt me and then we can deal with it as we go along. And again, if there's anything that you think of afterwards, please just drop us an email and we're happy to try and help. So we're going to cover who can be a legal blogger and why you might want to do it in the first place. Some practical things about how you work out which cases you might want to observe, issues around what you are and aren't allowed to attend, kind of etiquette issues relating to when you do attend, practical things around how you get permission to report and when you need permission to report. We will deal with the new reporting pilot that started on Monday. This training is not exclusively about that, but obviously it's an important part of legal blogging and hopefully will make legal blogging easier, but there is scope for legal blogging outside of the pilot. So it's not just about the pilot today. And probably as we go through, you'll learn a little bit more about the Transparency Project and we'll try to help you understand where we may or may not fit in with any legal blogging that you might do. So that's the plan. First of all then, what is a legal blogger? On one level, a legal blogger is anyone who blogs about law, but that's not what we mean for these purposes. What we mean for these purposes really is a duly authorised lawyer. That's a term that is now in the family procedure rules. Informally, we call that a legal blogger, but the term in the rules is a duly authorised lawyer. And it's a duly authorised lawyer who's attending for a particular purpose. They are attending for journalistic research or public legal educational purposes. So they're not a lawyer in the case. They don't have any interest in the case. They're not there as anyone's agent. They're just there for those bloggy type purposes. And permission to report may be required. A legal blogger has a right to attend. Then there's a separate question as to what they are and aren't allowed to report. So that's what a legal blogger is. I can tell you that I have just spent my day off this week at Cardiff County Court. I've attended 2 hearings today. You might wonder why I've spent my day off doing that. A little part of me is wondering why I did it too. But we are, all of us on the panel today, we have done legal blogging. We have found that it, apart from it being something that we think is useful for other people, we've all found it interesting and useful. So we wanted to tell you a little bit about why you may want to do this for your own purposes as well as for more altruistic reasons. So it is an experience, to be frank, even for an experienced lawyer, which will put you, I think, a little bit out of your comfort zone, which is not always a bad thing, but it will. It's a slightly odd experience that you're in your familiar environment, but you're not there in the role and with all of the entitlement that you would normally have as a lawyer in the case in the front row who has a turn to speak in. You're there with a slightly different hat on. You don't have rights of audience per se, although the judge might want to hear what you've got to say on reporting issues. And it can be a little bit uncomfortable. You can certainly see sometimes colleagues squirming in their chair at the idea of you sitting behind them, writing down everything they're doing. And of course, if you were to attend a hearing where you felt compelled to write about things that had not gone perhaps as they should do, that's quite uncomfortable to think about when you're talking about writing something about your peers or your judicial superiors, etc. And the other thing that is actually quite stressful at the start is applying for permission to report. It gets easier. It's a good learning experience. It's a really good way actually to teach yourself about these issues so that if and when they come up in your own cases, you don't have a complete freak out. When you go as a legal blogger, your only role is to listen, to write down, and to be ready with those little bits of the rules that relate to transparency and those specific bits of the law that relate to transparency. You can be on top of that. The lawyers in the case might not be. So quite often you'll attend court as a legal blogger, and actually you'll be the one that's got the best grip on those issues, because everybody else in the courtroom has a lot of other stuff to deal with. They've got clients. In the case of the judge, they've got bigger decisions to make, but everybody's got other jobs. You've just got one job. And so you can put yourself in a position where you are not actually the most stressed out person in the room. Obviously, one does not want to publish something that then turns out to have been a contempt of court. So it is important to make sure you get the right side of the line with anything that you publish. But that is not impossible to do. So don't panic too much about that. I'm probably making this sound really quite scary, but I'm trying to be frank with you about these things because I want also to tell you about the benefits of legal blogging. And one of the things, apart from that learning experience in terms of getting yourself up to speed with the law in this area, is that you actually also, when you're sat in the back of the courtroom as a quasi-journalist, you will have a completely different perspective on the court process. So where it says at the top of the slide there, perspective shift, you really will be surprised at the perspective shift. It's a little bit like when you're sat at the back of court as a trainee or a pupil, but even then it's not quite that, because you're not a lawyer for these purposes. So it's really good for your personal professional development. You will see advocacy techniques, client care skills. You will see, in a way that the lawyers with their backs to their clients don't see, how the lay parties respond to particular things, to things their lawyers say or don't say, how much of the lawyer's code the clients do and don't understand. So it's a really interesting learning experience for you as a lawyer, and it will teach you quite a lot, I think, about communication skills. And all of those things on the left-hand side of the slideshow about anxiety, about being the odd one out that everybody looks at with a side eye, about why on earth are you here on your day off doing this, and are you going to write something horrible about me? Don't forget that now there is a transparency pilot which started at the beginning of this week. This is endorsed now by the senior judiciary. And it's a thing. It's not quite as much of an out there thing as it was when we first started doing it. And certainly I can speak from experience today that the two judges I've appeared in front of today on cases I've attended have been really supportive of the pilot and have been worked really hard to make sure that the pilot did what it said on the tin, and that nobody was allowed to run a coach and horses through its main aim, which was to allow us to report a reasonable amount. So and the main purpose, that when we first made the proposals to the Rules Committee about legal bloggers being allowed to attend hearings, was that we wanted to be able to provide something that was a bit different to what the mainstream media could and do provide. So we wanted to be complementary to the mainstream media. We have a better understanding in some respects of what's going on, because we understand the acronyms and the code and the law and all of that. We can write about things in a different way than a journalist can, and both of them have value. So we're able to do something slightly different. We don't have word limits in the same way. We don't have editors who are saying, well, how am I going to sell this story in a newspaper? We can just write about things from a pretty straight perspective. So that's the kind of pros and cons. It is challenging, but it's kind of quite invigorating, as well as something for you to be doing alongside the day job, if you can find the time, which I know is a tricky one. So moving on to some of the practicalities, I'm going to race through some of the bare bones of the legal framework, because, as I say, there's quite a lot to think about. You don't need to have it all in your head at the same time. You need the headlines, and you need to know where to go if an issue comes up. The first thing to know is that most family proceedings are heard in private, not all of them, but most of them, and the rule is 27.10. Slightly different arrangements may apply in relation to appeals, so keep an eye on that. The second thing to know is that the media, and in that I include legal bloggers, so those duly authorised lawyers, are entitled to attend most hearings, but not all hearings. In terms of children cases, which is what I'm going to focus on for today's purposes, that really means anything apart from a conciliation hearing, or a part of a hearing that involves conciliation, or freestanding adoption type matters. Those are not covered by Rule 27.11 and the practice direction. And obviously, there is a provision in that rule for exclusion of reporters in particular cases, and I'll come on to when that might apply. We know from history that publication of judgments was very much encouraged, particularly when the former president of the family division, Lord Justice Mumby, published his guidance in 2014. Judgments went up and then they went down again, and publication is now happening, publication of judgments through the National Archives. And the default position in terms of what you can report in a children case is not a lot. It's not nothing, but it's not a lot. The default position in money cases, you'll be pleased to hear, is something I'm not even going to try and tackle today. It's an open question at the moment. It's complicated. And for our purposes, certainly our focus at the moment is going to be on legal blogging in relation to children cases. And that certainly is what the pilot applies to specifically. That really is a very bare bones outline. This is the rule that deals with the right of attendance. And as I say, the overarching term I use is reporters, those being journalists and legal bloggers. Polly, I think you were going to tell us about the criteria in a little bit more detail. There are essentially three types of lawyers who can be legal bloggers. One, people with practicing certificates. So if you're in practice at the bar, or you're a practicing solicitor, you're good to go. Two, a lawyer who is perhaps non-practicing, but they are employed by a higher education institution. So Julie, for example, is employed by Cardiff University. She could, if she wished to, attend under the auspices of Cardiff if she had a letter of authorization from them. That's the second category. And the third is a lawyer working with an educational charity registered with the president. And for your purposes, that's us, that's the Transparency Project. So if you're non-practicing, but you are a lawyer, and we approve you and give you a letter of authorization, you can go as a legal blogger, even though you are not practicing and don't have a practicing certificate. Polly, do you want to just outline the bit that's hidden underneath my head? I'll move my head.
Says, you can get in by virtue of having a practicing certificate. So I expect most of the people on the line tonight will be practicing solicitors or barristers, and therefore your authority will be that fact. As Lucy also said, if you work for a law school, faculty or department of a higher education institution, you can also go in under their auspices. Now, the phrasing of this in FPR 27 is a lawyer working for the law school, faculty or department. So I'm reading that as having to be in either the law school or the faculty containing law or department containing law, rather than any academic. And finally, you could go in under the Transparency Project. We are currently the only registered educational charity that we know of who is held on the list by the President of the Family Division. But note that unless you have a practicing certificate, you also have to be a lawyer with certain academic qualifications. So if you go in on behalf of a university or on behalf of the Transparency Project, you have to have some legal qualification, and it's a bit of a slightly weird mixed list. So the first one is you've got a qualifying law degree, or what used to exist as a qualifying law degree, or you've done the common professional examination, the graduate diploma in law, or the SQE, the Solicitor's Qualifying Examination, or you have a postgraduate legal qualification, or you've got the SciLEx Level 6 diploma in law and practice, or the graduate fast track diploma. All right, so in addition to being within a university or acting for the Transparency Project, you have to have one of those academic qualifications.
Brilliant, thank you, Polly. We will come back in due course to our approach to authorising non-qualifying lawyers to write on our behalf, non-practicing lawyers to write on our behalf. But to carry on with our thread about what the family procedure rules tell us, the important thing to recognise and be ready to state when you attend hearings is that Family Procedure Rule 27.11 gives you, if you're one of those lawyers, an entitlement to attend those hearings that we've discussed. You don't need to apply. The judge doesn't need to give you permission. The position is you're allowed to attend unless the parties raise an objection with reference to the basis, the proper basis of objection in the rules, and the court agrees, or if the court raises it of its own motion, you can be excluded. If there's any objection to you attending a hearing, you have a right to make representations. If the judge is thinking about excluding you from a hearing, which I can say from experience doesn't happen very often, quite often pre-pilot, there would be a sort of half-hearted attempt to exclude, which usually falls flat on its backside. But if a judge is seriously thinking about excluding you, they should be looking at what's proportionate, and it might be that they only need to exclude you for a part of a hearing rather than the whole of it. And the rules say that you can be excluded if it's necessary in the interest of any child concerned with the proceedings, for the safety or protection of a party or witness, for the orderly conduct of proceedings, or justice will otherwise be impeded or prejudiced. So what's not on that list, because otherwise what would be the point of giving us the right to attend, is, well, these proceedings are private, so of course you can't come in. That won't cut it. It is a representation that I've had to respond to on a number of occasions, and I can tell you it doesn't work very well. I just refer the judge to 27.11. And very often there is no proper basis for objection. And I think now we have the pilot, I think those sorts of objections will be less common anyway. So you probably won't have to deal with them as much. Now I'm going to tell you a little bit more about the law in relation to children cases. I'm not, as I say, I'm not tackling money cases. What we have put in the pack is that section of a slideshow that Polly and I presented at the FLBA conference a couple of weeks ago, which relates to financial remedy. I can tell you now, it doesn't really answer the question as to what the law is in that area, but it does set out the nature of the current debate about those complicated issues, so that you can do some further reading if you are interested in attending financial remedy cases to try and blog about them. Then that will be a good starting point for thinking about how you might go about it. But for the purposes of children cases, there are two main pieces of law that you need to have in mind when you're attending those hearings, and that you will understand the sort of framework through. One is Section 97 of the Children Act. You can think of that as the part of the law which protects the identity of the subject child, not for all purposes, but protects their identity as the subject of the proceedings. Okay, so there's a little recital that usually goes at the top of all orders, which I habitually correct because it says that the child must not be identified in public, full stop. That's meant, I think, to be a reflection of Section 97. There's no reason why you can't say Johnny Briggs won the sack race at Sports Day. A parent can put that online. What that little recital means, really, although it's not what it says, is nobody can say Johnny Briggs won the sack race and he's the subject of a case in the family court. That's the bit that Section 97 protects, not the sack race, but the fact that his parents are arguing about him in court. So it protects identity. Section 97 only applies during the proceedings, so it lapses when the proceedings end unless the court extends it. And if you want the reference for that, that's the case of Clayton and Clayton in 2006. It can be relaxed. The words of Section 97.4 say where the child's welfare requires it, but you have to interpret that in line with the European Convention on Human Rights. So if it's necessary to relax it in order to properly find a balance between freedom of expression and privacy, then it's permitted. It's a criminal offence if that is breached. I don't think it is really ever enforced, but it is a criminal offence. The second piece of legislation, it's a really ancient piece of legislation, Section 12 of the Administration of Justice Act. It is in your red book, you'll be surprised to know. And that protects the substance, the stuff that's in the documents, the stuff that's said in court, where the court's sitting in private. If the court sits in public, Section 12 doesn't bite. It relates to Children Act cases, which include Schedule 1, Adoption and Children Act cases, inherent jurisdiction cases, any case wholly or mainly concerned with the maintenance or upbringing of a child. So Section 12 will apply. Section 12 is not time limited like Section 97. It applies unless the court says it doesn't. And it works by making the prohibited information, the publication of the prohibited information, a contempt of court rather than a criminal offence. You have to read it in conjunction with the family procedure rules, and I put on the slide there, it's 12.73, 12.75 and practice direction 12G. Those all set out certain circumstances in which you're permitted to disclose this document to that person for that purpose, or informational documents. And if you do that within the terms of the rules, you're not in contempt of court and you haven't breached Section 12. And one of the things in those rules in 12.73 or 12.75 is that the court can give permission in the specific case. So that's the basic framework for Section 12. What you need to think about, though, and it's a really vexed question, is, well, what does information relating to the proceedings mean? Because that's the phrase, that's what's prohibited. Information relating to the proceedings. Well, I think that the most useful case on that is this Kent County Council case from 2004. It's a decision of Mr. Justice Mumby, as he was at the time. And it's the most useful one because it's got a really long kind of summary of the history of this issue. It goes through all of the authorities and it sets out in detail what the position is. So I think it's quite useful. And the gist of it is that accounts of what's gone on in front of the judge, prohibited. Stuff that's in documents, prohibited. Okay, not prohibited, and this is where people sometimes hadn't quite appreciated this was the position. The fact that the child is the subject of proceedings, the name, address or photo of the child, the name or address of the photo of the parties, etc. Because those are all protected by section 97, but not by section 12. The nature of the dispute in such proceedings is not prohibited. Now that's another phrase. What's the nature of the dispute in such proceedings? And so it's like peeling an onion. As soon as you define one thing, you've got another phrase that it's difficult to define. And what Mr. Justice Mumby also makes clear is that anything that's been seen or heard outside in the corridor, outside the courtroom, fair game. Also, another thing that catches people out, the text or summary of the whole or the part of an order made in such proceedings, which on my reading includes the recitals to orders. That specifically, if you look at section 12, is not something that's prohibited. So if you want your order not to be the subject of publication, obviously it can't be published anyway with the names on, because that would be a breach of section 97. But if you want to protect the contents of recitals, then the court needs to specifically say so, and it can do, but if it doesn't say so, then it's not covered by section 12, your default reporting restriction. And then the next definition we need to think about is publication. What does publication mean? Well, helpfully, it means different things depending on which piece of statute you're looking at. For the purposes of section 12, publication is a very broad definition. So it's akin to the definition in defamation proceedings. So effectively, if you send it to anyone, even if it's one person by email, it's probably a publication. Section 97 is different. It was specifically amended, I think in 2004, but at some point specifically amended so that publication, in terms of identification, relates to publication to the public at large, or it's behind my head, or any section of the public. So it's not the same. So again, it's a sort of mishmash of two bits of legislation, bits of rules, bits of case law, not entirely straightforward. And I'll probably skip through this, but you should know, and the Kent County Council case sort of tracks it through, that there was very, very restricted exceptions to section 12, at least until the point of that particular case. And there were certain things that we now know are acceptable or are permitted in the rules in practice direction 12G, which at the time were not, and were technically only happening by means of an inadvertent contempt of court. A lot of that's been remedied over time. More and more has been added to the list of things that are permissible in practice direction 12G, but you do need really to read it all in conjunction with the rules. Right, so the upshot of all of that is not a lot can be safely reported. I think of one example of a case where I had agonized over what I went legal blogging, and I asked for permission because I wasn't sure what I could report under the terms of section 12. So I thought I was safest to ask for explicit permission, which I got. And interestingly, subsequently, Sir James Mumby wrote an article in which he assumed that I'd done it because it was all entirely permissible without an order for permission. So we had taken, I'm sure he's right and I'm wrong, but we had taken quite significantly different views about where those boundaries lie in terms of section 12, what is information relating to the proceedings, what is the nature of the dispute, and what goes the wrong side of the line. So if you're in doubt, ask for permission. That's my my general approach. Realistically, permission is usually required before you can publish anything very meaningful. It's not that difficult to apply for permission. But that issue of you go to a hearing and you don't know what you can report until you ask for permission or ask for clarification is one of the reasons why the media don't go very often, because why would they? It costs newspapers money to send reporters to court, and if they don't know that they're going to get anything out of it at the end of the day, then they're probably not going to send them. So that's one of the reasons we now have the transparency pilot, to try to incentivize and make possible more attendance more often, because if you know you're going to be able to report something and you don't have to make an application, then all in all, it's a much more attractive proposition. So I'm going to have to speed up a little bit or we're going to run out of time. What you need to know for our purposes is that the court, under the family procedure rules, has the ability to adjust those are the default provisions. It can adjust them. So when I go to court, I say to the judge at the beginning, hello, I'll probably make an application to report at the end, but I'd like to hear what's said first of all, and then I can make my application in more efficient terms. And at the end of the hearing, I will tend to say, as I did in one today, could I please be allowed to report X, Y, and Z? And typically, if I've pitched it right, the answer will be yes, you can. And then I get that reduced to writing. That can happen under the family procedure rules. So that's fine. The exercise that the court has to go through, perhaps not in laborious detail in every case, but the basic exercise is set out in the case of Re S. It's at paragraph 17. It's these 4 propositions. It's a straightforward balancing exercise between Articles 8 and Article 10. This is primarily where you've got a dispute where people have different opinions about what should and shouldn't be permitted. But it's also an exercise the court will need to be working through in its mind when making decisions about reporting, even where they're not particularly contentious. But what you need to remember is you don't start from the position that it's private and therefore Article 8 is a trump card. Don't do that. You start from a clean sheet. You look at the specifics of the case, not sort of wishy-washy generalizations about, well, family proceedings are private. You look at the specifics. You look at the risks to the child, if there are any. You look at where those risks emanate from. Is it from any publication at all? Is it from identification? Is it from issues about identification of the placement, for example? So what Lord Stein says in his summary of the process is the court has to apply an intense focus on the comparative importance of the specific rights in the individual case. So in some cases, the public interest will be really, really, really strong, and it will outweigh even material concerns about child welfare. In other cases, child welfare will clearly outweigh a modest public interest. It will very much depend. The court will have to look at the justifications for interfering with or restricting each right. It's not necessarily one or the other. It's not necessarily black and white. The court can often say, well, if I restrict publication of this information, the name, the ethnicity, whatever it is, then I can permit reporting of other information. So it's a little bit give and take. And the court has to look at proportionality. So what's the least interference with Article 10 that I can justify without interfering too much with Article 8? That's the exercise. And it shouldn't be too much of an unfamiliar exercise, really. I'll skip through this. I won't skip through this slide, but what I will say is that it shouldn't be too much of an unfamiliar exercise, because we're all used to, as children lawyers in particular, doing that exercise of the sort of holistic analysis, putting the parallel analysis, putting everything in line, all the possible options. Should I allow no reporting? Should I allow reporting without the name? What if I allowed reporting without the name and without some other piece of information? Should I allow everything to be reported? And considering the pros and cons of each, the comparative risks and benefits, and then coming up with ultimately the most proportionate solution that is consistent with the welfare of the child. What you need to remember is that welfare is important. It's a primary consideration, not the primary consideration, not the paramount consideration, is a primary consideration. And welfare is kind of brought into the equation because it is a component of the child's Article 8 rights. That's what you need to be doing. That quote in Re W is really useful because, again, it reminds you it's not about rival generalities. You've got to be really specific and you've got to drill down. That's as important for lawyers who are representing parties who don't want any publication as it is for reporters who are at court saying, well, I would like to publish, and the reason I can justify it is this, and I think if I don't report this, then the balance is about right. So everyone needs to be going through the same mental process. Right, pilot. It launched on Monday. It's going to run for 12 months in Cardiff, Leeds and Carlisle. As I say, I'm in Cardiff now because I've been testing the waters. At the moment, it's only public law cases and magistrates are not included, but I gather those will be joined in due course. I have heard 6 weeks, 2 months and 3 months muttered about. I'm going to guess it's going to be in a couple of months that will be added in, but at the moment they're just trying to make sure they start with, I think, the cases where pretty much everyone will be represented, because that will make it easier for people to transition. Because this is quite a big change, and having attended Cardiff today, I know it is quite a big change. It's not making an enormous amount more work for the judges and for the lawyers, but it is something they're having to adjust to. So we need to just tread a little bit carefully. What the pilot does is it reverses that presumption. So when I was telling you about section 12 and the sort of default provisions, which prevent reporting of information relating to the proceedings, the pilot will operate on the basis that you are allowed to report, providing everything is anonymised. And if the particular circumstances of the case need some particular aspects not to be reported, or for reporting to be deferred, perhaps because there's criminal proceedings, then that can also be factored in. But it will operate by means of a transparency order. So there's a template order, as opposed to having to sort of create your own at the start of every hearing. And the court will be standing ready in those pilot cases to make that transparency order the minute that a reporter turns up, as some of us have done today. The court still sits in private, so it doesn't allow the public to attend. That doesn't change. The parents aren't allowed to go publishing willy-nilly. It just gives permission to reporters, so legal bloggers and journalists, and they have to report within the terms of the transparency order, whatever tweaks have been made to the template to suit the needs of the particular case. Typically, we are told reporting will be allowed from the end of the hearing in question. I can tell you that the 2 hearings I attended today, one will allow me to report pretty much straight away, and the other will allow me to report some information pretty much straight away, but with more detail to be deferred until the end of the case. So there's a mix going on at the moment, but that's fine. And so it will allow for some contemporaneous reporting, or more or less contemporaneous reporting of cases. What's also interesting about the pilot is it explicitly permits the parties, if they want to talk to reporters. And it also allows somebody who's attended, so a reporter, to share information with their editorial team. So obviously, so everything can be legaled, and so that whoever's going to be responsible for publishing can make sure that they don't do something they're not supposed to. I don't know how many legal bloggers will want to speak to the parties in cases of this sort, but I know some of the journalists who are interested in this area of work will welcome the opportunity to interview parents in particular if they're willing to be interviewed. But it's helpful that the pilot does allow that in cases where everybody's on board with it. And the last note on that slide is really just a reminder that the judge is in control. If the case does not, is one that should not be in the pilot for some particular reason, if it can't be reported, then there won't be a transparency order, or there'll be a very tight transparency order. I said I'd come back to the question of non-practicing lawyers, which I think for our purposes today will probably be, if there are any of you on the link, pupils and trainees, but there might be some other people who, for one reason or another, have let their practicing certificates lapse. You will either need, as we've indicated, to come in via your higher education institution, or if you want to do legal blogging, you'll need to come in under the auspices of the Transparency Project. what you need to understand about us is that we are a legal educational charity. We don't have any staff. We're all doing this in our free time. We have a small pool of legal bloggers and writers and trustees. And we need to make sure as a small publisher that we get things right and we don't publish material that is the wrong side of the line in terms of what's permitted, and that what we publish is consistent with our charitable objectives, which means it needs to be good quality and it needs to be clear and it needs to be accessible, because we're writing for the public primarily to try and help them understand what happens in the family court, whether that's things that go right or things that go wrong or just the general process. So for our purposes, if you would like to write for us, we would very much welcome that. We, I think, would like you to complete a write-up of a case or an article that you've seen about the family court. And to do that with the lay reader in mind. In the pack that we've provided, hopefully I remembered to include it, I've put in our editorial guidelines, which we put together to try and help writers to find a writing style which is more suitable for the public than perhaps lawyers are used to. What we tend to get if we're not very specific is we get people writing blog posts that sound like they're written for a legal journal, and they're in a really sort of traditional case summary format, and that's not always the best way to write for the public. What I would say also, when I was telling you about professional development and the benefits of legal blogging, this style of writing is quite hard, but it will make you a better advocate and it will make your legal writing better. So it's definitely a worthwhile endeavour. We need to be satisfied that you've got the legal skill and knowledge to stick to the rules and the limits of your permission. We will need, before we publish, a copy of any transparency order or permission order. And if we were to give you a letter of authorization, because you would need to be in an editorial sort of reporter editor role between you and us in order for the sharing provisions of the pilot to operate, we would need to be working on the basis that anything you published would be published on the Transparency Project site, because that gives us the opportunity then to have that proper editorial / legal oversight of it. There's no reason why, if you're a practicing lawyer, you can't go off and publish wherever you want. But if you want to have that sort of cooperative, editorial, supportive, checking, co-working relationship, then that's the way it needs to work. I hope that makes sense. Your pack contains, I think, quite a lot of these materials. I'm not going to go through them because I think they're probably pretty self-explanatory. You've got these slides. There is quite a lot of information out there if you want to find out more, quite a lot on our website. There's some on the judiciary website now. There are some training videos on the Transparency Implementation Group website, which is effectively the judiciary website. And the case of ReBR is really useful. It came out last week. It's effectively the first reported judgment from the pilot, and it's really helpful. Again, I haven't got time to go through it now. So this is where it gets a little bit sticky, finding and choosing a case. And it's one of the issues that we've been trying to grapple with this week. I can tell you my experience with Cardiff this week has not been entirely optimal. And I mean this is no criticism to the court staff, who were all extremely helpful, and we all know they're very, very busy. But the reality is that the lists in Cardiff haven't been published before 4 o'clock at all this week, which means you don't even know what case numbers are on the list until very late. And then that means it's hard to give advance notice. You don't have to give advance notice. It's not a requirement of the rules. You can just rock up and turn up at court and say, I'm coming into this hearing, please. But it is, I think, particularly given everyone's feeling their way through the new pilot, I think it's polite to do it if you can. But at the moment, it's very difficult to do that in practice. So the lists go up the night before. They're not very useful. Those of you who are in practice will be able to work out which are care cases and which are private law cases. But as I discovered today, some cases that look like they're currently outside the pilot because they have a P in them, so they look like private law cases, might be deprivation of liberty applications, but but you won't know that from the list because they no longer seem to have a sitting as a Section 9 judge written on them. Time estimates no longer seem to say the number of days in a fixture. So it's all a little bit tricky. You can try turning up on the day and checking the list and speaking to the usher to say, is there anything interesting? What type of hearing is this? But that depends upon you being pretty freewheeling and having time to go to a court and just suck it and see. You may have in either one of the pilot courts or a court that you know, friendly contacts that you can speak to find out if there are cases of interest on a particular topic. You might see that there's a published judgment, which, you know, in fact, something's been remitted on appeal, and you might want to see if you can contact either the court or the Judicial Press Office to say, I would like to attend the rehearing of this matter. We've done that on occasion. Alice has done that. And write with the case number in the judgment and say, please tell me when the next hearing in this case is. That's another way of doing it. And finally, and possibly likely to be the most productive, I think, is that we quite often get emails from individuals who say, there's an interesting case on this day, you should go to this court on this day. And sometimes we are looking for people to attend. So we will probably try to put together, once we get more legal bloggers interested, try to put together a contact list so that if we become aware of an interesting case, we may be able to pass that information on to legal bloggers who are, again, under our auspices editorially. So it's a bit of a mix and match at the moment in terms of how you find out about cases. But for the purposes of a legal blogger, you don't need something that you know is going to be a story. I find it's just quite helpful to go along and see what you see. If you're happy to be freewheeling, it will work just fine. There is a little bit more about conduct and boundaries in the pack. There's a guidance document that we drew up quite recently, which is intended actually for lawyers in the case and judges, but it deals with how to deal with the situation where a reporter turns up in your case. So it deals with it from the other side of the equation. But I think it's always important to be really mindful of the impact that you're having when you're going into a courtroom. I know today, partly because the pilot was new, some of my interventions probably made the hearing last a bit longer. And that's, you know, nobody wants to inconvenience anybody. You have to try and find the least intrusive way to say the things that you need to say. You need to remember that your right of attendance and your right to report are distinct. You will need to remind people of that from time to time. You will need to be ready to push back politely to say, well, hang on a minute, I'm not quite sure that's what the rules say. Please don't suggest I should be excluded because you're worried about identification. I can be here throughout the hearing without identifying anyone because the question of identification will be determined by what order the court makes about permission to report. We have adopted a process, I think, whereby we've become quite clear, and we've taken guidance from journalists on this actually, that if somebody emails us at the Transparency Project and says, please come to my hearing, we are not going to go and say to the court in response to a query from a lawyer or the judge, oh yes, it was the mother that told us to come. All right, that's just, I don't think that's appropriate. A journalist would never reveal their source. I think we're going to court in a journalistic role, and we're entitled to say, I'm sorry, that's not a question that I think it's appropriate for me to answer or for you to ask, although probably that sounds a bit rude. So that's the line that we always draw, and we just say, no, it's not appropriate to be asked to reveal our source. And I raise that because I have been involved in cases where there has been quite a lot of push for journalists to say how they find out about the case. Nobody needs to know. They're there, they're entitled to attend. Move on. It's a distraction. Don't let it become a distraction, and don't let it derail you from what you're there to do if you're there as a legal blogger. As I've said, if you can give notice, there's no reason why you shouldn't do. you will need to be really proactive in terms of asking for documents. Under the pilot, you're entitled to basic documents like case summaries and skeletons. If you're not going to court under the pilot, you're just in a different court, you'll have to ask for permission. And so chances are you won't get that before the start of the hearing. It's easier under the pilot because you're entitled, if it's a pilot case, you're entitled to see them, but you will need, whether you're entitled or not, to ask, remind, make sure someone's got your contact details so they can send it to you. And really, yes, just try and be as unobtrusive and melt into the background as much as possible, whilst also making sure that you don't bottle it, that if you need to seek clarification before the end of the hearing about what you're allowed to report, or if you think you've been told you can't report something, where there's a better balance to be struck, ask, can you say, well, Judge, I know you've said I can't report to the end of the case, but actually, can I report these 4 facts now? I did that today. I know you said I can't report till later, but can I report the following? And the judge said yes. So it's an easy thing to do. You just need to take a deep breath and do it. I think for the purposes of today, and bearing in mind the time, I'm going to skip quite quickly through this slide. Non-pilot cases, that's what I'm used to attending. Today's the first day I've gone to a pilot case, but some of you will not be near Carlisle, Leeds or Cardiff, and you might want to go to another court. So you might want to go and look up the transparency order and see if you can invite the judge to use it in the case you're attending. You will need, as I say, to ask for documents. You'll need to have all the rules to hand. And I did it again today, whether it's a pilot case or not a pilot case, note down as you go through the things that you think, well, this is a no-brainer. I obviously shouldn't mention whatever it is, child's ethnicity or whatever. And that was the basis on which I operated today. As I went through the hearing, I was writing a list of things which effectively will become a sort of summary of facts and information that I am now allowed to report. Have that ready, and then you can pop up at the end of the hearing and say, can I please report the following? And hopefully the answer will be yes, unless your list is, a crazy list that's going to identify the child. Ask for a written order, please, because otherwise we will find it difficult to know what is and isn't permitted.